Good evening. I hate it when I never fix that. Good evening, chat. Hello. It is Friday night. Just a little bit of a quick, not enough quick, but we're going to kind of work our way through it. Kind of like we call it, Indians home opener was today, so we're calling it the triple play. We got three different, groups we're dealing with tonight. We're dealing with Denims and her lawsuit, where Ethan Klein is suing the shit out of her for copyright infringement. Stuttering John, where his little fucking dumpster fire lawsuit is starting to run into some problems because people are pointing out to the court, hey, some shit's not adding up. And then Russell Greer, Russell Greer is getting sanctioned, but at the end of the day, nothing's going to happen to him, as has been par for the course so far. So I hate to burst your bubble now, but that is what's going to happen. Literally nothing. Sorry. It's just going to happen. That is the ultimate issue there. I know some of you guys I see in the chat are talking about the Smash JT lawsuit with Alyssa Mercanti. That requires its own thing because there's a lot there. There is a lot there that it is a lesson in many, 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 many things. It's a lesson in how not to use AI. It's a lesson in whether you want an activist lawyer versus a zealous advocate and kind of what the difference between those two are. And just an overall lesson about discovery handling. So we're going to get into that. We'll get into that another day. That's still unfolding, and that's kind of the issue here. Long story short, JT and Ron Coleman gave over like all kinds of evidence. Now, whether or not it'd be enough to sustain a finding of liability at trial, it looks like they've breathed all kinds of life into this case unnecessarily. And now it's, it looks like Alyssa and her attorneys played 45D chess, and it looks like they did a little bit, but then, JT voluntarily decided, I'll show you what stepping on a rake looks like, motherfucker. It just right into his face. So, So, we are going to get to it. We're going to get to it. Luke is saying it's definitely enough to get to trial. Yeah, but I don't know if they've got enough to get out of the jurisdictional issue. But remember, as they've pointed out, even if they don't and they lose here in New York, they've got enough to go forward in California. And yeah, so JT's kind of fucked right now. So we'll see, chat. We will see. But we're going to get to that another day. So put a pin in that, and we'll get to it later. But we are live tonight on YouTube and on Kick. And let's get, some of you guys already made some comments here. Iron Knuckles, been a member for 8 months, said, start with denim. Well, in honor of Darkside Phil, it comes in denim. We'll start with denim tonight. We'll start with Denims and her lawsuit tonight. Charlotte Jobs says, whoa, buddy. Cowbell air horn. Yeah. We will never have that kind of, stream deck like that. We got some Mimi clips, but that's it. We got some Mimi clips. EDW Raptor for $5 says Blueberry. I know. Oh no. And then T-Rex Travels for $4.99 says it is certainly a good Friday. Yes, it is, guys. I hope it's been time. If you've had the opportunity to reflect on it, today's the day that Christ gave his life for humanity. He shed his blood to wash away our sins and give us a chance at salvation and eternity. So pretty cool when you think about it. Humbling. Hope you guys have a good rest of Holy Week, and then for Sunday, I hope you have a joyous Easter. And then Jelly Jerome for £5 sterling. The King Sterling. He says, if you're available at 9 a.m., and I'm assuming that's 9 a.m. Mountain Time, so that'd be 11 a.m., and I might have like a half hour there. It depends on how some shit shakes out Monday morning. Somebody from the farm's got a Zoom link for the Greer versus Viatron dismissal hearing. That'll be interesting. I want to need Paji. We'll find out how that goes for Russell. But thank you for the heads up, Jelly. I appreciate it. The James has been a member for 1 month. Goes, woo! Just like Ric Flair. Was that Carl Jobs? Yes, that was. Yes. Just cover your lawsuit at once. Imagine you're a steamy locomotive, unstoppable. Well, steamy locomotive sounds really kind of gay. So I'll just be a... Glim Blim says, could she get a free lawyer in Cali? Talking about Alyssa. Oh, no, like, there'll be money to be had because they've probably got enough to get it to trial. And, you know, I think they're hoping they'll get damages and all that, and they'll just take a chunk out of JT's ass. So I think they'll be able to find somebody to help them take it. So, did you buy your Easter ham yet? No. I have to go pick up the groceries tomorrow from Giant Eagle. So I think the ham's in that. I think the ham is in that. If not, you know, we'll figure it out. My farts have color says we need a Zoom link for the Ricada versus Toe Zoom hearing. Well, remember, we're not, you know, some people don't want us to have that because, you know, I don't know, but, you know, I'm a free speech. Apparently not for that, though. Funny how that works out. But whatever. We are here. Ham, that's fucking disgusting, ham and pineapple. Pineapple's disgusting, so yeah. All right, chat, let's get started. We will start off with the Denims and Ethan Klein lawsuit. Remember, Ethan Klein is suing Denims for copyright infringement for airing and streaming the content nuke of Hassan Piker without any real commentary, without meaningful transformation or meaningful changes to things, solely to deprive Ethan Klein of revenue through clicks and watch time, as she has stated. So from there, Tyler T. Google says Denims is one sandbox I wouldn't pull out of. Oof. All right, so remember, that is the issue here. The other issue is there are some concerns about contributory copyright infringement because the idea is that Frogan, Casey Tron, and Denims, remember, he sued all three. Casey Tron is out, so it's just Frogan and Denims. And remember, the Frogan case is like died. There's been no movement. It's just like floating in midair. There's been no movement on it, and yeah, I don't know. I don't know what's going on with Frogan's case. It's just dead in the water. Like, I'd like to think that they had some sort of negotiations or something, or I don't know. For some reason, everybody's just kind of like, you know, plaintiffs and defendant are both kind of like they're both avoiding issues. So I don't know what's going on there. Yeah, she was tainted by Destiny, of course. Of course she was. But Ethan Klein is also suing the mods of the H3H3 Snark subreddit. And remember, what's a snark? Snark is just like Reddit's gay term for A-logging. That's really all it is. There's a bunch of gay logs! Goddamn A-logs. And that's... Oh, fuck. Uh-oh, shit. I just spilled something and the lid wasn't on that. Fuck. Uh-oh. Oh, no. Ooh, buddy. Ooh, that's a lot. I spilled this. The Nuln oil. Uh-oh. I thought the lid was on this fucker. Son of a bitch. Okay, now it's on all the way. And I am moving this up to somewhere else where it's safe. And I can't touch it. And then we're going to have to mop all this up. Uh-oh. This shit is nasty. Oh, look at that, chat. It's all the oil. If you guys don't know what it is, it's an oil you use to do oil washes on things. Helps you do, it's acrylic. So not as problematic to deal with. And I need to, we're going to have to spray some cleaner on this real quick, guys. Hold on. Where is my, there we go. All right. We got to take a little bit of our thinner and cleaner here. We're going to just sprinkle a little of this on the mat, and I could wipe it down because it's kind of like sticky already. We're just going to go, boop. And we're just going to kind of wipe down the mat real quick. There we go. That looks good. On the bottom of our keyboard. All right, there we go. Sorry, chat. Sorry for the delay. Live TV and all that. Live TV. So. God, that was scary. I was like, that shit is kind of expensive, too, for paint, given it's a Citadel paint. So that wasn't fun. That wasn't fun. Clyde is a rebel. Oh, the whatever you call this shit, the NULN oil. I don't know what the fuck you call it. It's for the oil washing. Did I oil wipe the keyboard? No. That's like $8 a game workshop juice spilled. Yes. Yes. Yes, that was actually a spill of that. Yes. Yes, that was rough. Did I spill oil on Clyde? No. Gooning lotion? Yeah, that's it. I masturbate and model paint. That's how we do it here. That's how we do it. How come Clyde's always being disciplined? Because 2.0 has it out for him. I don't know what to tell you. I don't know what to tell you. Oh, that's no good. It's no good. I was just checking to see what you guys. You guys have. Dude, you're that Warhammer meme. Yes, thank you. So, and it's funny because I don't use it for Warhammer. I use it for my bolt action guys. But they look so much better oiled. They look so much better with an oil wash on them. I will tell you that. I will say that much. Now, from here, guys, we are going to go on to getting back to Ethan Klein and Denims' lawsuit. We are in this. Remember, there are. Hold on here. Why is this not working? I accidentally canceled shit out when I was trying to wipe everything up. There we go. Anyway, this is a copyright lawsuit. It's out in the Central District of California, out in LA. And that's where the Central District is. And remember, Ethan Klein and his attorneys, Lex Juther and his Jewish hatchet man attorneys that are out there, they have made a couple of allegations. They had that massive complaint. What are they actually going for here? Well, the first count is copyright infringement directly, and it's against Denims. The second count, and there's two claims of relief. The second one is a contributory copyright infringement against the H3 Snark mods. And these mods, being Reddit mods, aren't people. They're some sort of faggot and or tranny. Their whole thing is that they helped facilitate and encourage and induce for these things to happen. Now, I know you're going to say, well, wait, that's the same thing the Farms is being accused of. Yes. But with the Sony versus Cox decision that came out, you really have to make affirmative actions to get considered liable for contributory copyright infringement. And many of the examples that they cite in the Supreme Court opinion that came out about a week and a half ago really reflect poorly on the Reddit mods. Like, it does not look good for them. It does not look at all like they're not going to have a good day. They're not going to have a good day in this situation. But Ethan Klein is still trying to get a subpoena done for their identities and the identifying information that Reddit has stored up. That case is still pending. So that's going to be a while. In the meantime, Ethan and Denims came up with an interesting thing that they're going to do. And they are going to address their claims right now. And they're not going to wait. They're not going to wait. And there's a bit of a risk here. There's a bit of risk. There might be information that Reddit has, or that once they get the identities of these people, that they might be able to gain more information to use against Denims. Although I have a feeling they probably have everything that they're probably going to get at this point. Very much in the, I give Ethan Klein credit that I bet they plan this out well in advance. I assume they have what they need. I assume that they have what they need. But where do we start out at? Well, we start out about, 2 weeks ago. And what got sent to the court? Well, it's a joint stipulation to lift the stay. And remember, this case was put on hold while the issue about the subpoena was pending. Everything was put on pause, and everybody agreed not to do anything until the subpoena issue was resolved. And that's being resolved up in San Francisco. So they wanted to, now they're seeking to lift the stay for the limited purposes of filing a motion for partial judgment on the pleadings. Now, you might say, what's a partial judgment on the pleadings? Well, it's exactly what it sounds like. This is basically a motion for summary judgment against Denims only. They're asking for a judgment on the pleadings against Denims. That's what this is all about here. So they point out that on March 3rd, the court stayed this action because of the things going on with the subpoenas to Reddit and Discord. And they say the parties, though, in the meantime, meaning Ethan and Denims, their attorneys, have met and conferred. And they've agreed that Denims, upon approval by the court, may file a motion for partial judgment on the pleadings as to TEI, that's TED Entertainment International Incorporated, that's Ethan Klein's company, claiming copyright infringement as to one of the two works at issue. So here we go. Here we go. This becomes an issue here because remember, there are two. The other thing here is Denims is accused of two copyright infringement issues. There's the nuke, the content nuke, and then there's a countdown episode that H3 did, part of their H3 podcast stuff, that Denims was involved in basically watching and pirating, more or less, is what we're going to argue, based on the theory that Ethan Klein is alleging here. So there are two works. One of the two works they're going to go ahead on. So what does this mean for them? Well, one of these two works, they think there's enough evidence, and I have a feeling it's probably not the content nuke, because that's really where all the Reddit people were truly involved, but it might be the countdown episode. They haven't, discussed it yet in length in any of the filings from what I could see, but it's going to be one of the two. You guys are looking to see what I spilled. Well, so from here, Denims is basically going to file a motion saying, Judge, we agree on all the facts in regards to one of these works that I'm accused of infringing on. Ethan's going to file a response, and he'll say, Your Honor, we agree to all the facts as to this one issue, this one work that I have copyright on. Did she violate copyright or not? And the judge is going to make a decision on those pleadings, meaning what's already out there so far, the complaint and the answer. Remember, Ethan's complaint was 80-some pages long for Denims. It had all kinds of exhibits, all kinds of proof in it. The judge is going to make basically a summary judgment motion on that one work. And you could do this. You could ask the court and say, look, just make a decision right now. No discovery. You just tell us what you think. Now, obviously, Denims thinks they could probably win. I don't think they will. Obviously, Ethan Klein thinks he's going to win because otherwise they wouldn't have consented to this. But they're fine with it, and they're fine with it because they think they're going to win. And somebody's going to be in for a big fucking surprise. So they're asking for the court to do this. So they've notified the court, we have a stipulation, but here's what they want to do. They want to allow this to proceed. Oh, jeez, come on. They believe allowing the motion for partial judgment on the pleadings to proceed while the quash motion lingers will promote judicial economy, and courts love that because it's not waiting around, and could resolve or facilitate the resolution of the primary claim of infringement and possibly this entire action irrespective of its outcome. Yeah, they might just take a bite out of Denims' ass at the end of the day. Ethan Klein might say, yeah, you know what, fuck it. Or if the judge determines, you know what, Denims did not infringe, then obviously the mods did not infringe. So, Ethan could lose all the way here as well. So they want to let the stay for the purposes of the motion for a partial judgment. They will meet and confer on a briefing schedule, and they'll submit a proposed briefing schedule for this. And we've stipulated and agreed, and they're asking the court to do it as well and agree to it. Well, the court came out on the 30th and said, you know what? I will agree to this. I like what you want to do here. So upon consideration, we're going to allow you to do this. You guys are going to be allowed to play baseball. And it says, upon consideration of the joint stipulation, and for good cause shown. That's always something you see there. That's always good news. The stipulation is granted. The stay is lifted for the motion for a partial judgment on the pleadings. Parties shall meet, confer for a briefing schedule on the 30th. Well, a couple days later, being yesterday, we actually have the briefing schedule. So we know what's going to happen here. Here's the timeline we're looking at, guys. So this is a joint stipulation setting what's going to happen here. Let me do this. Amon Erez Uwu says, is Denims trying to avoid discovery? No. I'm sure he's already got everything he needed from Casey Tron anyway. And there would have already been requests for production, meaning please turn over documents pertaining to this. They would have already been asking for this stuff already. Greencap saying, could Ethan be doing this to get a feel for the court for future hearings? No, this is like a very drastic step. If you're going in there and demand, I want a judgment right now, Your Honor. I don't think you're worried about the court feeling it out. You're thinking there's no way in hell we're going to lose. No way in hell we're going to lose. Which, once again, it's a very... Asking for these, judgments on pleadings or summary judgment, one side can, you may ask for it and the other side wins completely. You may partially win and partially lose. You may win completely. There's all kinds of things. All kinds of things could happen. So this is the briefing schedule. And what do they do here? So here's their schedule on this. They talk about all the different things they've done so far. So here's how it's going to work. The parties have met and conferred and proposed the following schedule. Denims will file her motion for a partial judgment on or by April 17th, identifying a proposed hearing date of June 5th. Ethan will file their motion on or by May 1st. Denims, remember, guys, it's limited in what you get to do. There is motion, response, reply. That's all it should be. So what you're seeing with Russell Greer, where it goes like ping, pong, ping, pong, ping, pong, ping, pong. No, it's, Denims serves, Ethan sends it back over, and Denims gets one more chance to send it back over. She gets a reply. Denims will get to file her reply on May 8th. So that at that point, the court will have a month to figure out what they're doing. So during the meet confer process, they realized there was an issue with one of the exhibits that had been submitted already. So they stipulate to the authenticity of the video file, and it's a corrected version of Exhibit K, which Ethan Klein will submit to the court and fix the issue. So they noticed there was a problem, but they all agreed, and they're all taking care of it. This is proper lawyering. If you're on either side, you figure out a way to resolve the problems, and you get it done. This is how it should go. This is what they should be doing. So this is going to be done. They point out, once again, Denims files by the 17th. Ethan responds by May 1st. Denims responds again, does a reply by May 8th. And they have their hearing, will be proposed at least by June 5th. Now, the court may set a different date on its own, but presumably they talked to the court ahead of time about setting up a date for this. And we'll find out what happens from there. But it's stipulated and agreed to, which, what does that mean? The court's going to agree to, because the court's going to be thrilled these guys are coming up with something. So signed by Ethan's attorneys, signed by Denim's attorneys. And yeah, there they go. Now, that is the status of it. So we're not going to see anything for a little while. We've got about 2 weeks before we see anything, because the 17th, I think, is it? Yes, the 17th is a Friday. And then 2 weeks after that is May 1st, another Friday. So we're going to be waiting about 4 weeks to get the basic idea of what everyone's going to do. And then a week after that, Denims responds again. But by that point, we'll kind of already have an idea what's going on. But that's the game plan right now. That's the game plan right now. That's the Ethan Klein and Denims saga. For now. Once again, Frogan's case, I don't know what the hell's going on there. I would love to know what's going on with that. Casey Tron, remember, she's done and dusted. And then, yeah, Denims. She is the last of the Mohicans right now, and we'll find out what happens. Yes, 2 weeks. Trust the plan. That's... Oh. Yes. But anyways, good luck to Ethan Klein. May he make these cocksuckers suffer at that point. All right. So that is the Denims and Ethan Klein nonsense. The next thing is Mavka saying Frogman disappeared into a sandstorm. What are you talking about? All right. So the next thing, guys, is Stuttering John's lawsuit against Carl. If you guys, this is the Dabbleverse shit. Stuttering John, the fucking goober from Howard Stern's show. You're like, wait, that guy's still around? Yeah, and he's not dead yet either, surprisingly. He's on the internet. You can go see him out there. And oh, Frogan. Oh, you're saying Frogan. Okay. I think Frogman, it's like, what do you mean? There were like Navy swimmers, like combat swimmers were disappearing in the desert? I don't get it. Yes, Frogan is the hijabi. Although technically Denims claims she's like Arab too or something. I don't really know. She claims it at least. So, but anyways, it's from the Dabbleverse, and he's suing Carl, the guy who runs the Who Are These Podcasts channel, and then also Shuli Agar, the guy who runs the Shuli Network, and the Shuli Network is like, well, actually, the whole Dabbleverse is all about A-logging the shit out of Stuttering John. That was its raison d'etre, but it's its existence, its essence. If they were Mr. Meeseeks, that was their purpose. It's that purpose has since now kind of like blossomed into other things, and then you got like the Hackverse and all that with Melton, and then Nick apparently thinks he's a comedian now. That is what's going on there. We do have a notice of some things that have happened, though. Remember, last time we talked about this, Stuttering John's lawsuit was moved from New York City, from the New York City area, all the way up to Rochester, New York, where Stuttering John alleges that the DabbleCon, which is where they basically sat there and shat all over Stuttering John for a weekend, was where it happened. And as I talked about when we were reading through all the initial filings, that's where it should have been filed anyway, was all the way up in Rochester, New York. And for those of you, once again, if you guys don't know what we're talking about here, this is New York. Right here. Here is New York. You know, all that. There's Long Island. And then here's New York. If your geography sucks. So, anyways, New York City, way down here. Rochester, New York, where Carl lives, and this is where they did the DabbleCon, all the way up there. So that's a very long drive for Stuttering John. You know, like he's down in Florida or wherever the hell he is. But where he wanted to do it, this is, you know, like 6.5 hours away. It's like 6.5 hours away. So this is the proper place for it. Now, what do we have? The first thing that got, and, you know, we'll just start off with this because there's a court date being set. This was filed today at 1 o'clock. And you can see that because it says it up here, 4/3/26. The judge in this matter has set this for a hearing in an in-person conference. I mean, Stuttering John's got to scrape up a bus ticket, but it's an in-person conference in chambers at the Hall of Justice in Rochester, New York. The failure of any parties to appear as provided herein will result in this matter being disposed of. So if Stuttering John can't scrape out enough change out of his couch, he might be fucked if he's not there. Remember, he's suing Carl and Shuley. So that's going to happen April 22nd at 10 a.m. That's a lot of hand job money. And I don't know. For Stuttering John, it might be. I don't know. I don't know how much he charges for handies. He might be able to just go on the I'll jerk you off with a hand that has touched Howard Stern. And there's probably a lot of guys who would be all about that. So he actually might be able to make a lot of money really quick, given how things are. Did I say 10 a.m.? Okay, yes, 11 a.m. There you go. Now, this is the interesting thing, and we talked about this previously. Stuttering John had filed a bunch of affidavits, and I think we went through all of them. And I think you guys, if you don't remember me, every time something happened with these affidavits, they were like carbon copies of each other. Exactly, and each time Stuttering John, he did an affidavit one day, and then he was in another state the next day, and he signed another affidavit, and then he signed another affidavit in another state on a different day, and they were all like right after each other. And then people in his life, apparently family and friends, were signing affidavits, but they were literally carbon copies of things. It was very, 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 very weird. It was very weird. You know, it's almost like, well, it wasn't like, it was. They were fucking fake. They were fucking fake. I mean, that was my conclusion. And, you know, obviously, and I think a lot of people agreed. And I think the court's kind of like, yeah, I kind of want to know what this is all about. Because here, this is a letter. Remember, chat, in New York and in the Northeast, a lot of things are done by letter as a type of briefing and filing and motion practice. So you would file on letterhead. You know, in the Midwest, this would actually be an emotion with a caption and everything. This is a little different. Mavka says John is in Cape Coral. Oh, God. Damn. I feel bad for the people in Cape Coral. That's not good for them. I mean, shit. That's rough. That's rough for those people down there. That's rough for them. You know, too bad, like, you know, instead of Cape Coral, like, move him to, like, Imalaki or something where the fucking casino. Oh, I think he'd probably like that too much, having the casino there. But isn't, like, Imalaki where it's, like, all ghetto? I think that's what my mom said about down that way. So I asked her, like, what's that town name? She's like, Imalaki. And she's like, I'm like, what's there? And she's like, oh, it's all ghetto. You don't want to go there. I'm like, okay, fair enough. Fair enough. Fair enough. Now, what's going to go on here? Why is trolling Stuttering John even a thing? Because Stuttering John's cringe and an asshole, and he, you know, it's kind of one of those deals. He deserves to be felted. That's the thing. He deserves to be felted. So that's the issue. So I can't. Yeah, he has to drag his broken wrist to Rochester. Yeah. Apparently, he was given those too aggressive of a handy, or he tried to, jack off some sort of bull, and the guy jerked too hard. I don't know. I don't really know how he broke his wrist. I don't really fucking care. I'm just gonna. That's my headcanon here. That's my headcanon. So, what does this letter say? What does this letter do? So this is the judge saying, I represent all the defendants. Remember, it's Carl. Remember, he's suing them individually. He's also suing them and their channel, their company. And then he's suing Shuley. And then he's also suing the Shuley Network in the above case. And he says they want to bring an in-person conference in Monroe County, which is where Rochester is, prior to the court's decision on the pending motions and cross motions. Remember, those motions haven't been addressed. All the motions, motion to dismiss, all the motions, everything has been filed. Remember, there were like 100. There were 100 entries already on this case, and nothing's happened. The court needs to sort that all out first, and that court has to get caught up on all this. But remember, in January, there was a motion to transfer from New York County, where Manhattan is, to Monroe County was granted. So, all the motions, and the motions that were here, there are pending motions pursuant to various New York civil laws, and ultimately New York's anti-SLAPP law. Because remember, Stuttering John is basically claiming, he claims all kinds of economic crime or economic violations, economic torts, staking his personal image, name, image, and likeness, more or less. And then also just they're being mean to me. Well, that's free speech, motherfucker. So there's an anti-SLAPP motion pending, a motion for a stay. There's also a motion for an expedited decision, and a motion for mandatory costs and fees. And then there's a bunch of other motions that have been filed. Stuttering John, there's also Stuttering John filed motions as well, and those were all transferred up here. So they request a conference because there are two issues that should be raised to the court. And this is, this is a big problem here. Kind of funny. The first issue is Stuttering John's attorneys may have quit. Wait, you mean to tell me that John probably didn't pay these fucking guys? No way. I'm shocked. I'm shocked that a lolcow would not fucking pay his attorneys. But the two attorneys who were on the record, Tabor Benedict of the term Benedict Advisors, filed the original complaint on August 7th, 2025. And this is the weird fucking thing. They amended it immediately on August 12th and then again on September 12th. So within a month, they amended it 3 times. And one of the amendments was for, they just fucking wasted an amendment. There's another attorney, Bennett Susser of Jardim, Meisner, Salmon, Sprague, and Susser, entered his appearance after that. They believe the plaintiff's attorneys may have quit working on the case, and communication has broken down between the attorney and client. The case on the document, however, remains possibly with no one at the helm. Now, here's the problem. Even if you aren't being paid, you can't just say fuck it and leave. You have to make a motion to withdraw. Now, you could point out, attorney-client issues have arisen. We can't continue on. This is a brand new case, so you probably get a chance to withdraw. I'm sure that, you'd have to go into court and explain that. And what happens from there? Well, this sounds like for the Stuttering John side of this, it's, I told you this before, from this old-timer judge, he called it a Rule 1 violation. Or if you watch the Lincoln Lawyer, they're having trouble getting hold of a very important witness, a Mr. Green. And if he's not paying, they're going to quit. So you can't just leave. They say Tabor Benedict has disappeared. And they say attorney Tabor Benedict, who's filed every substantive document, may have abandoned this case. And he says in November I wrote a comprehensive letter urging him to drop this lawsuit and provided reasons for it. The guy never acknowledged or responded to the letter. The last response or communication was last year on December 16th at 10:43 a.m. And in that email, Benedict responded to an inquiry from defense counsel, meaning this guy here. Oh, who's their attorney? Daniel Savalos, this is Shuley and Carl's attorney, who this guy's actually been, once again, I'm assuming he's a very good attorney, but he's just been doing the work, which when you're looking at compared to Stuttering John's attorneys, makes him look like a rock star. I'm sure this guy's good, but once again, this is just an example of competent lawyering versus dog shit lawyering. And they say that by saying only that Mr. Benedict shall defer to Bennett, and that's the other attorney. Let off some steam, Bennett. Since then, defense counsels emailed Mr. Benedict at least 8 times with no response. In retrospect, the 100% deferral might have been a subtle message that Benedict was no longer working on this case. Yeah, but you can't just quit. You can't just quit. This is interesting, though. Information has since emerged that may explain why Benedict has stopped working on the case and is ignoring communications and notices. It appears that Mr. Benedict may have brought an action against Mr. Melendez, perhaps for unpaid attorney's fees. The image at right appears to be the caption of an arbitration case. Benedict advisors versus John Melendez. Now, here's the thing. Taking your client to arbitration like this is some Jew shit right there, man. Wow. Like, get some fucking money up fucking front, dude. Like, did they really take Stuttering John at his word? Oh, I'll gladly pay you tomorrow for a hamburger today. It's like, come on, man. You deserve to get fucking hosed if that's what happened. You deserve to get hosed if that's what you did. Come on. Say, counsel wishes stress, however, this is an image that has been shared on social media, including at a shortcut here. I don't have any way of verifying yet, and there's no shortage of pranksters in this online universe. They say, and indeed, one commentator on the website says it looks like a photo of a Word document. Yeah, it does. It's not clear. It looks like this, and this right here is kind of the dead giveaway that this is a Word document. But we really don't know. Bella says, or the check bounce. Well, that's why you don't take check. You could take a bank check. But no, I take a money order, but I ain't taking a fucking personal check. There are like maybe a handful of people I take a personal check from, and the number of them would be on my hand, and one of those would be my mom. But I ain't taking a fucking personal check. Oh man, I no attorney there, right? Taking a fucking personal check, you need another fucking hole in your skull. So, could I get paid in gold coins? Yeah, sure. You came to me with a bunch of fucking Krugerrands, I take those as payment. As long as you can tell me they're not stolen. You come to me with Swiss gold. Like, I've had clients like give me the title to their motorcycle or tools, or guns. Now, when it comes to guns, I need proof they bought the gun. Because I'm not taking some clapped out SKS that looks like it's been sitting in a septic tank. Because I don't want to deal with that being stolen. But if they could bring me paperwork on a gun that they bought and show proof of that, yeah, I'll take it and hold on to that. And then I've had clients say, well, here's your money. And I'm like, well, here you go. Or, if they can't do it, it's like, all right, well, I'm taking that and, it's mine now. So there are ways you can get paid. Could you pay me in fairy dust? No. When cash is offered, the price goes down for just about everything. Well, yeah, of course, because cash, IRS, never heard of her. So can't spell IRS with cash. So yes, that's a great thing. However, based on my own experience with this, the caption in the first part of the case appear legitimate. Of course, the document would need to be authenticated by either Benedict or Stuttering John. And if it's true that Mr. Benedict is now embroiled in a fee dispute, or if there's just been a breakdown of communication, then yes, Benedict cannot simply quit working. In addition to his ethical obligations, he has a responsibility to this court and opposing counsel. You do. You just can't stop work if you filed every document. By contrast, his co-counsel filed his own entry of appearance, and that's it, nothing else. And that's important because the other attorney filed everything. The complaint, amended complaint, the opposition, the cross motions, and the affidavits and exhibits. All of these are subject to the anti-SLAPP and other sanctions. And we're going to get to other sanctions in a second. And this is important. Benedict is still subject to the court's sanctioning jurisdiction. If you just quit, the court can sanction you. The court can refer you to the bar. It can make you pay a fine. It can sanction you, especially because some of these affidavits are like fucking bogus. And if you violate your rules of candor to the court could sanction you for that and punish you. You offer payment in Ronnie and oil? I think I think Supreme Court would frown upon that one. Also, conflict diamonds, they would probably frown on that one too. So, they point out it's well set under the rules of professional conduct that an attorney may not unilaterally cease representation due to a fee dispute or other disagreement with a client. Yes. And here's the thing. If permission for withdrawal is needed or is required, a lawyer shall not withdraw without permission. You can't just quit. You have to ask for permission to withdraw. And it further mandates, in order to do so by a tribunal, a lawyer shall continue representation, notwithstanding good cause for terminating the representation. Now, there might be times where you have to continue. Like if this is the day before trial, you're not quitting. You're going to have to handle it. But this early on, they're probably going to have the hearing on the motions. And then at that point, Benedict would probably be allowed to withdraw. And then they talk about the model rule. And the model rule is promoted and promulgated by the American Bar Association. So we have the rules of professional conduct, and every state basically copies the model rules proposed by the American Bar Association. The model rules contain the same directive requiring continued representation where the court so orders. And say, even if non-payment of fees might constitute grounds to seek withdrawal, and it probably is, in their fee agreements and their engagement agreements, it probably includes if I can quit if you don't pay. And that's acknowledged in writing that if you don't pay, I can quit. So none of this is going to be a shock to John. I'm sure he's going to be like, "Whoa, I don't know," or whatever, however he does it. Now, that provision permits merely a motion to withdraw. It does not authorize abandonment of the attorney's responsibilities to the client in the case. They say once an attorney has appeared in a matter, a fee dispute does not relieve your obligation to continue litigating until you're allowed to leave. Now, what else has happened, though? Well, Stuttering John himself has suggested there might be some sort of problem. No, I will not do that for heroin chat. They point out, although the other attorney has communicated intermittently, several weeks ago, Susser reached out for the purposes related to the civil rules, or civil law. I forget. Anyways, after discussion, Susser said he would get back in touch soon. 2 weeks later, he called to say he had been busy and that he'd be in touch soon. That was 2 to 3 weeks ago. Defense counsel's heard nothing since. So it's been a month, really, since they had any communication with the other attorney. I was going to say, it's my understanding John never pays. Yeah, I mean, that's always been my understanding. He doesn't pay on shit. Like, doesn't he get evicted, too, on things? Isn't that part of his issue? Jelly Jerome says, let's say you really want to get off a case due to a lack of payment. What's the good tactic? There's not really a tactic. You just file with the court and say, Your Honor, there's a breakdown in the attorney-client relationship. There has been a failure by the client to fulfill their obligations under an agreement. You don't have to say specifically this motherfucker won't pay. You church it up and you use the reasons listed and craft a way around it because you don't hurt the client. You still have a duty to your client not to hurt them in that. And here is, for example, we'll just go to we'll go right here to the New York rules. Rule 1.16. Now, if you're talking about this, we're not worried about this, about the, conflicts here, the issues about supporting it. We want to get down to the lawyer shall withdraw. Okay, well, what shall withdraw? Well, when you know representation is violating the rules, when your mental condition materially impairs your ability to represent a client, that's another one. You're like, well, what does that mean? Well, like, if you know you can't handle it, you shouldn't take it. Like, for example, if you're in the middle of dealing with cancer and you know you're going to be laid up, you shouldn't be taking representations. But we got to get down to the may withdrawals, because that's where we're talking about the discretionary withdrawals, when you're seeking permission to withdraw. So you may withdraw from representing when it can be accomplished without materially adverse effects on the interest of the client. The client persists in a course of action involving the lawyer's services that you believe are fraudulent, that he's used your services to perpetrate a fraud. The client insists upon taking action which you have a fundamental disagreement with. The client deliberately disregards an agreement or obligation of the lawyer as to fees. And then really, here's the stuff you can do here. The client fails to cooperate in the representation or otherwise renders the representation unreasonably difficult for the lawyer to carry out an employment efficiently. This is something you would really try to focus on here. You could say 5 because he's not paying, but you'd really try to focus more on this here. I would, just because you don't want to make him look bad. You want to make him look bad. Yes, John is not the sharpest spear in the quiver. Well, he'd be the arrow in the quiver. You wouldn't put spears in the quiver. Unless that was the joke. They say the lawyer's inability to work with co-counsel. If, he hires not like it's in your own firm, but he hires a separate attorney and he's in a different firm and you guys don't get along. You're like, fuck it, I got to quit. Your mental or physical condition. So let's say you're representing somebody and you get cancer or you suffer a mental breakdown. You're like, look, judge, I got to get out. Court will let you get out generally. Stuttering John freely assents to the termination. There's a lot of things you can do here, but those are the big things, what they're going to ask to get out. And where is, that's not right. Where is, uh-oh, chat, I think I lost something. Oh, there it is. God, I lose the tabs. What about a stroke? A stroke would also be a similar thing. Yes, severe medical emergency. I thought Artie was a cokehead. He certainly lost his nose over it. Yeah. They say, meanwhile, the plaintiff has suggested there's and what ultimately, Jelly Jerome, you can't constructively get him to fire you. That could lead to bar issues. So no, you just be like, look, he hasn't paid. That's it. That's all you got to do. So Stuttering John himself suggested there's a serious breakdown. On or about March 14th, Stuttering John made public comments that he's not aware of what his lawyers are doing, and he only gets his information from people other than his lawyers. The problem is Stuttering John's a retard, so who knows? And then, yes, there is Stuttering John claims attorney tried to settle with Julie and Carl behind his back. Well, that alone already, and this is here, if he makes this claim, there's already a massive issue. And he says that. He's like, I think one of my lawyers tried to say, settle, I think. That's what people tell me. I don't really follow it. Then how the fuck do you know what's going on? How do you know what's going on? And it says plaintiff suggests communication with the lawyers John's lawyers have broken down to the degree attorneys are trying to settle without his knowledge and authority without informing him of developments of the case, which is another violation of the rules. And this is the attorney now saying, well, I think it unlikely that Mr. Susser would attempt to settle the case without his client's authority. The plaintiff's public statements raise concerns that if defense counsel relied upon Susser's offers to settle, they would be without the plaintiff's authority, meaning they're saying, we don't think he would do it, but if he did, we have reason, like anything he'd say, we couldn't trust. So yes, we need to come into court and the judge needs to look at everybody and say, what the fuck is going on? And yes, this is a great time Stuttering John to say, are you just a retard or are you saying things that really happen? They say no attorney responded to this draft letter a week ago. Oof. And they say, as further evidence, there may no longer be working on this. On Sunday at 2:50 p.m., the undersigned emailed a draft of this letter to both Susser and Benedict as a good faith effort, asking them to meet and confer and to avoid having to file the letter. Meaning, he's like, look, guys, if you don't talk to me, I got to file this because I don't know who the fuck's in charge. But if you meet with me, obviously I can't file it because at that point I've talked to you. So just get in touch with me, please. And it says, given the professional responsibility implications of the letter, I assume Benedict or Susser would immediately respond to deny or at least address the issues. For example, if the image on the arbitration case is false, if Benedict is not bringing that, I would expect Benedict to immediately protest and insist he's still in the case. Also, if it's not true that Susser had a breakdown in communication, one would expect Susser to immediately send an email saying the concerns are misplaced and he's still on the case. That's not what happened. Nobody responded or even acknowledged receipt of the letter. They completely ignored it, which is a sign that they kind of bailed, Bo Beats Black Sheep says, I predict an elephant roar in your near future. Is that some gay thing Stuttering John tries to do or something? I don't know. Anyway, there's Stuttering John looking pretty rough. They say the second potential issue, and this is that one's a big one for the attorneys. Like that's an issue of they're going to have to answer for what the fuck's going on. But this is the second, there's two issues that they could be sanctioned on. And then Stuttering John could be facing sanctions himself on this issue because he's signing these documents. If you're signing documents, your ass is attached to them. So if your client signs something, yes, as an attorney, you're liable for it because you're filing it and signing it. But if your client signs it, that's their ass on the line too. That's their ass on the line as well. Now, here is the second thing. He says, I have recently learned that one of plaintiff's witnesses may have submitted a knowingly false affidavit to the court in opposition for the motion to dismiss. They say in opposition to the pending motion, plaintiff filed no less than 5 affidavits. One of the affidavits from Mr. John Melendez, 4 from other individuals. And remember, guys, they're all identical to each other. They're literally identical. All the things are identical. We went through those. Remember, they are literally just copy and paste names. Not just similar, identical. Yeah. One affidavit's from an individual, JM, who also goes by the name Vegas Beer Sales Jerry. I learned after the plaintiff submitted these identical affidavits that JM, or Vegas Beer Sales, admitted to on Melendez's show to Stuttering John, he simply signed whatever affidavit the lawyer sent to him, no matter what it said. Well, I mean, there you go. I mean, I'm not going to go back through and watch fucking Stuttering John. I don't think any of us should be forced to do that. So we're not going to click on any of this shit. Thank God it's not live. So thank you to Attorney Savalos for not making us suffer through that. And they point out and this is the thing, I was confused too. It's unclear why these were submitted because the facts in it are largely inadmissible and irrelevant. I know, we went through that and we're like, what the fuck were these points? I don't know. You mean you don't know Stuttering John's ever entertaining hand horn bits? No. I mean, the only horn thing I want to see him handle is a flash suppressing cone on the front of an M1 Garand as he puts it in his mouth. Then I'll watch him play that. But otherwise, no, I don't really care for Stuttering John. I watch clips sometimes. Oh. Chet Manley says, turns out the rule about not getting involved with the cows includes being their lawyer. That's not true. You can be a lawyer representing cows, but the biggest problem is cows pick attorneys who are just like them. Or you see people down in Texas, the Antifa guys who got convicted for their terrorism case. You picked activists or people who are fellow travelers in your cause. And you guys are both down with the struggle. That's not what you need as an attorney. An attorney needs to be a counterweight. it shouldn't be somebody who's like, oh my God, he's my bro. It should be somebody who's not afraid to push back. You don't necessarily see eye to eye on everything. There's got to be a little difference, because if you guys are completely congruent, you can't see through that. But if you're staggered, okay, we can see through this a little bit. You need a little bit of, you don't pick someone who's like you. That doesn't mean you go out and pick, like, I would go out and pick some, like, raving Trotskyite, but I'd pick somebody maybe a little more mellow in terms of how they view things than me, because that helps give you a little bit of a balance. So, you got to check. Craig says, were you a Howard Stern fan? I forget if he was syndicated in range of Ohio. He was, but no, I was an O&A. I listened to O&A. I fuck Howard Stern. I Googled myself. No, fucking Howard Stern's gay. He was gay! I just thought he was fucking retarded. Like, no, Opie and Anthony was good enough. So. They say in the video in the screen capture above, an audience member asked Jerry why his affidavit's identical to the others. Melendez certainly does not appear surprised. Indeed, he tosses the question directly to Jerry to answer it. Do we really need the exclamation point on that? I mean, yes, there was also Ron and Fez, but yes, homeless shopping spree, sex for Sam, all that stuff. Jerry's response is credible too, given that the other affidavits are identical to each other. I was going to say, especially like back when I was a kid, like when I worked my summer jobs, though, like, you're working as summer help. So like whoever's driving like the work trucks or whatever, they're listening to like 100.7 WMMS. So we hear Chad Zumach. So it's like all this shit kind of comes back circular for me in life. So, but anyway, says Jerry's response is credible too, given that other affidavits are identical to each other. And here's the thing, chat, when it comes to like Jerry's statements, nobody would say that unless it were true. Why would you say that you just signed an affidavit without reading it, and that, you wouldn't say that thing unless it were true? You wouldn't say that thing unless it were true. So there's going to be a lot of credence to that he's telling the truth. Coast to Coast was peak. Yes, it was. And they say, if the affidavits are indeed false, not the words of the affiants, then I believe I am duty bound to bring this attention to the court before the court considers them with the plaintiff's opposition. That's true. If you have reason to believe these are fraudulent, you have to raise it. Now, remember, Stuttering John's, his ass is grass. This guy, Jerry, could face sanctions, and the attorneys could face sanctions. A lot of people could get hemmed up in this. Now, I understand on the, when the dabblers are going to be like, Stuttering John's going to prison, yay! And he's going to get fucked to death by some bull. No, that's not going to happen. Like, you're not going to get perjuries, nothing like that. But are these people going to get, like, butt fucked by the judge? Probably, and it'll be hilarious. I was like, kind of like my Tukey thing. Yay! It's not going to happen here. So, they say the notice of an available dates for in-person court dates. And they say, look, Your Honor, we request an in-person conference. Should the court wish to consolidate this date with oral argument and evidentiary hearings on the pending motion, meaning this motion right here, the defendants can be ready for that as well. Defense counsel submits his upcoming unavailable dates. And he's like, look, Your Honor, any dates but these I can be ready for, which is, impressive. He's making his calendar flexible, which is good, because that, and the date got set April 22nd, and it comes right in between those. So respectfully submitted, Daniel Savalos Esquire, just kicking ass right there, kicking ass. So yeah. Mm-hmm. Jerome says, anybody remember lady died from O&A? I remember, like H Cup Jane, Pat from Munaki. I think he had they had a porn star come in and blow him. I forget which one it was. Pat from Munaki. There were a bunch of people. I remember. It was a good show. Yeah, but John, sounds like John's fucked. Sounds like John is fucked. So, he better gonna have to chug a Michelob before he goes into court. because he's not going to have a good day. So that's where we are with Stuttering John. The shit winds are a brewing. The shit winds are a blowing, chat. Not brewing. The shit winds are a blowing. And yeah, Stuttering John is going to get, yes, good and fucked. Yes. So if you like that and you want to see Stuttering John get fucked, like, boy, howdy, you are in for a treat coming up. He is going to get fucked. Very hard, too. Very, very hard. So will his attorneys. So will his attorneys. If you want to see them get fucked, boy, howdy, you're going to be in for a treat as well. Let's see here. Ag says, what is this lube we speak of? Was not lube. Jelly Jerome for £2 sterling. The King Sterling says, I love Charlie Cox. I love Cox. Well, there you go. It's 2026. You can do that, apparently. MLS, making a lot simple. David, hope you're doing well, man. Thank you for being here. Friend of the show as well, chat. Sean wishes he was half as talented as Russell Greer. You're right. I wish I was half as talented and my face was half as paralyzed as Russell's. EDW Raptor says, I'm paying for the super chat with a personal check. Oh, no. EDW Raptor then also says, can I pay you with beads? No. Unless those beads are like conflict diamonds. No. You're going to have to pay me like Commander Zero. Oh. Let me see here. Is Vince the lawyer's greatest con he's ever played on Stuttering John? Yeah, so I don't, and this is something I don't follow this shit enough. Well, is Vince the lawyer using John just to fuck with him, or does Vince the lawyer hate Shuley and Carl and is using John as a torpedo? Because if he's using John as a torpedo, this is kind of like taking that torpedo and just like not actually firing it, but you're just like dumping it off the side and letting it sink. I don't understand what the situation is here with them, but I've heard like the Vince the lawyer guy is fucking crazy in his own right. So nobody's buying Clyde's insincere woos. He's not electable. Don't you say that. Don't you say that, chat. Stuttering John's on the Bush Light now. Hey, there's nothing. Okay, you know what? I may not be some highfalutin, guy from the tri-state areas like Stuttering John, but I grew up on Bush Light. There's nothing wrong when you open up the can, you hear Bush. Bush Light is some good stuff. Is some good wholesome beer. So, no, Vince is fucking with John. John is Charlie Brown and Vince is Lucy with the football. Oh, I thought he hated Carl and Shuley as well. So he's just fucking with John. I mean, God, there seems like there's easier ways to fuck with them. Grew up on alcohol? Yeah, I drink a lot of alcohol. Yeah. Especially I remember it was 7th grade. Or actually, no, it was 8th grade. 8th grade. Had some fucking Wild Turkey 101. Whoa, that was an interesting first time drinking alcohol. But yeah, also we drank Bud Ice. We drank Bud Ice and Natty Ice when we were in high school. You could get a hold of it and you could get fucked up a little better on it because it had a higher alcohol content. So, Natty Ice was great, and then you got to college, and that was like the thing. Everybody drank Natty Light, and I still remember you could buy a case of Natty Light with the $10 bill, tax included. That's in my day. So, let's move on. Yes, I went to Bowling Green State University. Yes, the jewel of Northwest Ohio. The Ivy. One of the Ohio Ivies. Really, 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 truly, truly. The Harvard of the Maumee River. The Harvard on the Maumee River. That's really what it was. It's all, yeah, it's some good stuff. It's some good stuff there, chat. So it was good. I am a Rust Belter. I'll drink Strohs. I've drank Strohs, but not a lot. I'll drink it, but I've never been like in my fraternity when we would do like alumni for like homecoming, the alumni would come in. Yeah, they would. A lot of those guys drink. Like apparently that was like the beer back in the day was Strohs. So it's like yeah, like I remember one time one alumni came out with like 5 cases of Strohs, and we're like, all right. Wasn't bad, but it's like it's not, it wasn't used to it. Wasn't used to it. PBR is not. I can't do a whole lot of PBR. Couldn't do a lot of PBR. Like if it came to that or like Miller, like MGD, like oof, I'll drink PBR, but oh buddy. I got sick a lot on PBR. Even more on Low Life and MGD. So oh. Did I go to the best law school in my state? No, I went to the 8th best law school in Ohio. Now it's the 9th best law school. Stephen Cooper says strawberry banana Sobe in Cuervo during class. I remember when Sobe was like the thing. Like that was hot shit. I never tried all those flavors. Never tried those flavors. Yes, Stroh's was the thing until Coors could come east of the Mississippi River. And that's the thing, guys. If you've ever seen Smokey and the Bandit, that was a real thing. You could not get Coors east of the Mississippi. And that's why they had to go run beer like that. They had to go run some Yellow Jackets into Georgia. And, because the boys were thirsty in Atlanta. And there was beer in Texarkana. So... I miss alcohol. The 9 out of 10 fired basketball coaches drink of choice. That's funny. So, yeah, I remember when Four Locos came out. I was still in high school, though, when Spark came out, and it was like 7% alcohol at the time. I don't know if it still is, but like it was just in the energy drink aisle at one of the gas stations we had. So, like, I remember there were, like my senior year, especially like towards the end, like in the spring, my senior year, like getting a couple of those and like drinking them at school. Drinking like a 20 ounce of 7% alcohol and just getting fucking ripped. It was good. It was good. All right, chat. Moving on to Wassail Greer. Remember the Budweiser energy beer? No. Don't recall that. I still can't believe there aren't dry states. There are dry counties, but I don't think they're dry states. But yes, Wassail Greer. All right, guys. Russell Greer suing the Farms for contributory copyright infringement. Remember, the Sony case actually, it doesn't eliminate the cause of action, but based on the things they state, which would constitute copyright infringement and the things they cite as examples, it does reinforce the Farms is not engaged in that. So it reinforces the Farms position. It doesn't kill Russell's case outright, but it really, really hurts it. It really hurts it. Now, what happened this week? A bunch of orders were put out. So this is a memorandum decision and an order. And get ready, chat. Some of this sounds good, and then a lot of it's depressing. A lot of blackpilling here. A lot of blackpilling. A lot of blackpilling here. So this is the thing here. They're saying that Russell Greer moved for sanctions against Josh Moon and Matthew Harden. Court denies both motions. They point out that the court denies Russell Greer's motions because first, the court can't even consider Rule 11 sanctions against Josh and Harden because Russell Greer failed to serve his motions prior to filing them as required by Rule 11. Remember, you have the 21-day safe harbor. If you don't do that, you can't file under Rule 11. And then as a pro se litigant, 28 U.S.C. 1927 talks about attorney's fees. Well, you can't recover attorney's fees under that if you're pro se. So once again, you have to serve for a Rule 11 motion for sanctions. You have to be, it must not be filed or presented to the court if the challenge paper, claim, defense, contention, or denial is withdrawn or corrected within 21 days of service or within another time the court sets. So the motion for sanctions can't be filed for 21 days. That means if the other side actually does a Rule 11 problem and you serve them with it and say, you have 21 days to fix it or I'm going to drop this on the judge's desk and fuck you with it. If they fix it, you can't drop it. It goes away. So, and the 10th Circuit requires strict adherence to the safe harbor provisions, and that's what the safe harbor is. These provisions are intended to provide a type of safe harbor against motions because you can receive it. If you refuse to withdraw or acknowledge it candidly, then yeah, you can have a problem. But otherwise, you have to have the chance to correct it if it really is wrong. Russell Greer does not contend he served his motions on Hardin prior to filing them. Further, when Hardin opposed the motions on that basis, Russell did not reply to refute that fact. Thus, the court is left to conclude that Russell Greer did not serve his motions. Because Hardin said, wait, you didn't do it. And Russell didn't go, no, that's not true. So the court's like, look, I have to assume because you didn't say anything, that's correct. Next one, pro se litigants cannot recover attorney's fees. That's really, guys, it is what it is. That's something, you know, I don't really need to do a whole lot more with that because it's oh, hold on, shit. I gotta plug in my phone charger. My phone's about to die. Hold on 1 second. Sorry, guys. 2.0 says we're being too loud, so I had to close the door. David, you actually bring up a question here. No, your answer to your question is no. But I'm speaking to Matt LaRosier, Fudbusters. He has indicated that in the 11th Circuit, though, an attorney who represents himself can seek attorney's fees, I guess, under some filing standards out there. So it's not entirely impossible, but you have to be an attorney yourself already. But I don't know the conditions necessary for that, but he explained it to me at the one point, so... hold on. The answer to Vincent is yes. Who? What? Useful mistake. Service of legal documents. Yes, is one of Russell Greer's biggest foes. Yes. Yes, that is the problem here. Russell Greer can't follow instructions, and that fucks him over every time. And remember, guys, the rules will make or break you. And if you don't follow the rules at all, you're generally fucked. Now, remember, Russell Greer has tard armor. So he's been able to survive this a little better and weather the storm a lot more than regular people would or other parties would. So, you know, at some point you'd like to think that would change, but for now, nope. It is not changing. So, suffer, chat. Suffer. Now, they say the court doesn't need to consider why any of the alleged conduct violated 1927 because they can't award fees. And yes, statute provides that an attorney who multiplies proceedings that cause unreasonably and vexatiously may be required. Courts have said pro se litigants can't recover. This includes attorney's fees as a sanction. So not even as a sanction. According to the court will not grant the fees he requests and therefore denies. So once again, Russell Greer denied. Suffer, Russell. Suffer. The next one, that same day, the judge they started cleaning. I know when this started dropping, everybody's like, oh my God, they're clearing house. It's going to be the end. No, this was just a little bit of a blip. There was a flurry of filings from the court, but not enough. Not enough. So there's another order that came out. Another one. So they talk about when Russell Greer initiated this case, he filed a sealed motion to proceed in forma pauperis, meaning as a pauper. Meaning he was poor. He was poor. The court granted it. Russell later conceded at a hearing that he could pay the full filing fees at that time and still support himself. Therefore, the court ordered Greer to pay the full filing fee, which he did after a lot of fucking torture. Since then, the farms went ahead and questioned whether Greer filed it in September 2020 and wasn't committing fraud. They wanted leave to review the motion and an order directing Greer to preserve certain records. For the reasons below, the court says no, denies. The court denies the IFP motion to review the records. They claim they need to view the IFP data, investigating their belief Greer did not qualify for IFP status when he filed the motions. The defendants contend that if their belief is true, the court's required to dismiss it, and it is. They say, although that proposition is true, defendants have not provided any legal authority demonstrating the court should permit them to view the motion. Further, the court is not persuaded that their knowledge of Greer's description of his financial status in 2020 would aid their investigation. If defendants' investigation proves fruitful and uncovers evidence Greer did not qualify, they can proffer that evidence. They already have in an appropriate motion. They have already done that. Therefore, they deny the motion to view the IFP paperwork. They also deny the motion for a preservation order. And it says a party seeking a preservation order must show there's concern that potentially relevant evidence will be destroyed, causing harm. And then courts consider the factors to determining it. The level of concern the court has for the continuing existence and integrity of the evidence. Any irreparable harm likely to be a result of the party seeking the preservation, absent an order. And then 3, the capability of an individual entity or party to maintain the evidence sought to be preserved. Because preserving evidence can be very burdensome and costly. Remember, guys, we talked about that before, like putting discovery or putting documents on magnetic tapes, for example, can be very expensive. But in Russell's case, it's just like, don't throw away your phone, dummy, and don't fuck with it. But, oh, that's a nice message. Good news. They say the court must exercise restraint in issuing preservation orders, and they should. They should. They say, although the defendants did not cite the relevant factors, the court turns to consider them. And they say that they have not persuaded the court that it should have concerns about Greer's capability to maintain the existence and integrity of his records. They assert that Greer, in the request for Greer to preserve the records, Greer declined and outright refused to preserve them. However, the email correspondence only shows that Greer did not directly respond to their request. Without more, they haven't shown the court should have had concerns about this. And they say, as of the second factor, they have not shown they were sufferable irreparable harm, absent the order. In fact, they admit once a discovery stay in this case is lifted, they will have the ability to subpoena the relevant financial institutions for records. Notice the one thing they're not telling Hardin is that you don't have the right to do all this. So, Russell, when you keep on saying, yes, but they're also finding out if you're a fraud. Defense further indicate those institutions preserve records for 7 years. Thus, defendants will have capability to obtain the records they seek from relevant institutions when the stay is lifted. Probably not, because this court's going to drag this shit out till 2027. Honestly. David says, yes, this could be a subpoena of his financial records. Yes. Yes, they can go to Ally or whatever banks he was using and, Chime and Cash App and Zelle and Venmo. They can subpoena all that shit. They can ask for subpoenas. Russell could move to quash them. And he'll probably lose. If these judges were paying attention, yes. Yes. Pun of me. Yeah. Suffer, Russell. Suffer. And then useful mistake. I saw you made a comment here. I did not know that. Apparently, Russell Greer admitted to committing loan fraud to the Nevada Supreme Court. That's fucking hilarious. That is fucking hilarious. So, that is very, very funny. Yeah, guys, remember, Chili DeCastro has all kinds of tarred armor, too. He spent a couple of months in jail, but even then, that was wrongful. He shouldn't have been in jail. That was a wrongful arrest, I think. I still do. Yeah. Did I hear about Russell admitting to the state Supreme Court that he engaged in loan fraud? No, I hadn't been following Russell. I need to get back into, like, following stuff a little better. Is Russell Greer Kim Blandino's bastard child? I've heard he's got all kinds of new shit in the courts, too, right now, where he might go to prison for it. I'm going to have to look at it. So they've failed to show irreparable harm. In sum, they have not shown a significant cause to do this. Therefore, the court denies it. So Russell's been denied, and now the farms have been denied. We're 1-1, chat. And then guess what? Another thing dropped on the 31st. Another order. Another order. Another order. Another order. All right, hold on here, chat. We're going to leave this. There we go. All right. Order. So this is the thing here. Pro se plaintiff Russell Greer moved for permission to email documents to the clerk of court for filing and receive email notifications. The court granted that. The farms now moved to revoke that permission for the reason below. The court denies. Remember, this is the one where they're saying, take it away from Russell. He abuses it. So the court denies the permission revoke, and it says the court may on its own or a party's motion revoke the ability to file by email or electronic notice after a determination that's been abused. So what are some things that are abuse? Non-conforming documents, incomplete documents, to avoid missing a deadline, like you file one page of it, you file clearly just one page of a brief. And then in the next morning, while you worked on it all night, the rest of it magically shows up. Documents that needlessly complicate the proceeding or harass the court clerk and opposing party. Documents containing viruses, ransomware, or malware. People do that shit, guys. People do that shit. They do it. Defendants contend that it's necessary because Russell does not keep up with his emails. He's claimed he did not open these emails from certain courts. He said that. He doesn't open his shit. And they claim they can't litigate if Russell is permitted to continually claim he does not receive filings. So why are they denying it? Because they haven't shown Russell has abused his permission. The defendants don't argue that Russell violated any of the examples. And they say the court's not persuaded they are unable to litigate this case if Greer fails to open or read email notices, because Mr. Greer will do so at his own peril. This is bullshit because you're not like, no. Don't threaten him because you're not going to do anything about it. Russell does it at his own peril. It doesn't matter because you won't do anything to him. We've already seen that. You've already threatened him with sanctions, including dismissal. And then what did Russell do? Get more sanctions, and you didn't dismiss. The court is tard guarding, so this is a bullshit statement. It's an actual bullshit statement. The court has previously warned Greer of that fact, but you'll let him keep doing it. You keep giving him more and more chances. Accordingly, the court denies the motion. Suffer, Matthew Harden. Denied. We got Ricada, chat. Denied. Another one, chat. Another one. Like, this shit, they carpet bombed this stuff, man. It's like coming in like a Vietnam airstrike. Just running along the line of contact, dropping napalm. Dropping snake and nape, chat. Snake and nape. The court made both an oral and written ruling staying discovery in this case. And they say, while that stay was in place, Russell requested a subpoena from the court, which was issued. Upon discovering that Greer obtained the subpoena, defendant's counsel contacted the clerk. Say discovery was stayed. And they say counsel for, basically Harden, also filed a notice with the court regarding Greer's violation. Consequently, the clerk entered an order declaring subpoenas invalid. Defendants now move for sanctions against Greer under Rule 26G in the form of an award of reasonable expenses, including attorney's fees. Greer opposes the motion. Did I cover docket entry 458? I think I did. Hold on here. Let me... Oh. Okay, yeah. Oh, hold on here. Yeah, no, I did not cover that. Sorry. Yes, this came out. Well, we'll get to that one here. We'll get to that one here in a second. We'll get to that one. Because that one's going to be kind of important. All right, chat, here we go. Greer opposes the motion, arguing the subpoenas were about information about the John Doe defendants, meaning Rustard and Mosef Jartelli. In his complaint, it was a sincere belief the discovery state did not apply to subpoenas. Greer contends a stay order didn't encompass his ability. And Greer says he moves to modify or clarify the stay order. And it says Russell Greer requests a court clarify whether the order applies to his ability to obtain subpoenas. And he says, on the alternative, modify the stay order, meaning if I was wrong, allow me to do it. And they say, based on the analysis of the court here, they grant the motion for Rule 26 sanctions. Remember, Rule 26 is discovery, and denies the motion to clarify. So what do they do here? They say, the court grants a motion, and that, because Greer committed a violation, and that violation was not substantially justified, meaning there wasn't a good reason for it. So they say every discovery request must be signed by at least one attorney or the party personally. By signing it, the party certifies to the best of their knowledge and belief that the discovery request is consistent with these rules and not interposed for any improper purpose to harass, cause unnecessary delay, or needlessly increase the cost of litigation. There's a further certification. If it violates it, says without substantial justification, the court on its own must impose an appropriate sanction, meaning they must impose a sanction on the signer. Remember, guys, if you sign on the line, it's on you. The party on whose behalf the signer is acting or both. The sanction may include an order to pay expenses, including attorney's fees. And it says to determine what is substantially justified, the court applies a standard of reasonableness. The ultimate issue is to decide whether or not the signer conducted an inquiry into the facts and law. And it says Russell committed the violation by obtaining the subpoena, which violated the stay order, thus was inconsistent with the rules and obtained for an improper purpose. In opposing the motion, Greer appears to argue he didn't commit it because it was his sincere belief the stay order did not prohibit him from doing so. Greer says the stay order didn't encompass his ability to get a subpoena and that he wrote down what the court said. Discovery was stayed, but it didn't apply to serving the John Does. It says despite Greer's belief, the transcript containing the court's oral ruling staying discovery makes it clear the court stayed all discovery. All discovery. Pending the resolution of the motion to dismiss, with the sole exception of Greer's production of documents under a prior court order. Meaning that shit out of Utah, Russell. Your protection order against Josh. You have to produce that. That was the only thing that was accepted from that order. That was the only thing. Yes, the problem is for Russell Greer, nothing is reasonable. Well, everything is reasonable for Russell, yes. Russell thinks everything is reasonable. The court's written order is likewise clear and on point. Thus, Russell Greer violated Rule 26 when he got the subpoena. It was not justified because he failed to conduct a reasonable inquiry into the scope of the stay order before getting the subpoena. Instead, Greer relied upon his subjective recollection, which is incorrect. That's the thing, chat. If he had done it ahead of time and the court had said yes, and it turns out the court was like, oops, I was wrong. Okay, well, that's fair. But he didn't. He just went on his own. And the required objective standard of reasonableness, the court must conclude the violation was not justified. Therefore, the motion for sanctions is awarded. To determine the amount of sanctions awarded, the court orders the defendants to, within 14 days, file an affidavit and a cost memorandum. They already did all of this in the motion. With the requested award of reasonable expenses, including attorney's fees. Greer may file a response brief of no more than 10 pages within 14 days after that filing. So a month from now, chat, this will all be filed for consideration. The court denies modifying the order. They say no clarification is necessary because everybody can understand it, even you retard. They'll say, look, we're tard guarding, but you got to be able to read. They say it's established above the court's oral ruling and written ruling make the scope of the state order abundantly clear. Abundantly clear. Like, you knew what the fuck we're doing. You knew what the fuck we're doing. There is no question, Russell, you didn't know what was going on here. You knew. You knew. And if you didn't know, well, then I guess you're too retarded to be here or be involved, which that's a Russell problem. That's a Russell problem. That is a Russell problem. And notice they have the transcript here. My intention is to grant the motion to stay, but instead of granting the motion to stay discovery until everybody's served, and that's where Russell probably is trying to argue, my intention is to grant it until the court has a chance to review the motion and dismiss. And he says, I have stayed discovery until the motion to dismiss is decided with one exception, and that's Russell Greer producing the documents. So, once again, Russell heard what he wanted to hear, and now it's going to cost him. So, and as you know, the court could choose this motion to modify as one to reconsider the stay order, and they don't like Russell's reconsidering. You know, and how do you get a motion to reconsider? You include an intervening change in controlling law, new evidence that was unavailable, and or the need to correct a clear error to prevent manifest injustice. None of that's here. None of that's here. You know, this is only being made on grounds of a mere disagreement. And we're not going to allow it. So here are the sanctions for Russell. There are Rule 26 sanctions. Here's the problem, though. Whatever Matthew Hardin submits for sanctions and fees and costs, remember, the court's going to look at it and probably cut it in half, as they have done before. They tard guard and say, oh, Russell's too poor to pay that. So Russell, whatever happens here, Russell's still going to come out smelling like a rose. And then he's going to fuck around and file a motion to reconsider. And then he's going to blah, and it's going to jerk off for another 6 months. It's never going to happen. It's never going to be enough. So Russell takes an L here, but in reality, it's just a little baby L. And this little baby L may not even be anything at some point. It may not even actually be anything. Russell's going to fuck around for months on end. Russell will fuck around for months on end, and that's going to be the sad part of this. The sad part of this. Another order comes out on top of all of this. Another actual written order, chat. And you're like, oh my God, what's going on? If only the court had invested this much energy early on, this case might not be out of control. Yeah, I guess. But yeah, we're not there. So Russell Greer filed motions for protective orders under Federal Rule 26. And Greer says the protective orders are necessary because protecting Greer and his associates from being annoyed and embarrassed by Hardin's annoying discovery, and to prevent further harassment and defamatory insinuations. So what happens? They get denied. So, and notice they point out that the main problems are Hardin's contacted parties not involved, and Hardin has disclosed witnesses to Greer. Greer contends such conduct constitutes doing discovery. Greer is incorrect because he does not contend that Hardin has employed any of the discovery methods under the FRCP. So if you're not doing discovery under the discovery methods, that's not discovery. They point out, indeed, Hardin cannot do so under the stay of discovery. Simply put, investigation is not discovery. Yeah. He's merely notifying you of what he's found. And it says, because Hardin has not conducted any discovery on behalf of the defendants, there is no Rule 26 violation, so there's no protective order. So it gets denied again, Russell. Greer. Now, here's the problem, chat. This comes out, and I talked to Matthew Harden about this. This is the other thing that came out on March 31st. Order number 458. So remember, Matthew Harden asked for a scheduling conference. Okay, well, the court has determined that the stay of discovery previously imposed shall remain in place until the court rules on all pending motions, chat. And there are motions. There are tons of motions still pending. So who knows when the fuck this is actually going to happen? This is literally going to go into stasis. This case is in purgatory right now. It's in limbo. It's where the unbaptized babies go. So they don't go to hell. Are we going to do models later? Yes. We're not going to hell, chat, but yes, at that time, the court will lift the stay and address scheduling. So there are still a ton of motions that have not been done. This is a fucking joke. This court is letting us just drag on. Shame on these guys. This is absolute bullshit. And I talked to Harden about this. I was like, yeah, he's just gonna have to stay put. Like, there's nothing he could do now. But that's make it the court's problem at this point. But this is absolutely disgusting. Absolutely disgusting. We are not going to watch Ben-Hur. We're not going to watch Ben-Hur, chat. But there you go. So some wins, but some big fucking setbacks. Like, this shit's never going to end. It's never going to end, chat. And even with the sanctions, nothing's going to happen. Nothing is going to happen. So, Suffa chat. Benjamin, or B Jammin, says, I loved old school For Loco. I think you were the only person in the world who did. That must have been the only person on the planet that it was more like liquid meth than blackout in a can. I had like one of those once. Like, whoa. I couldn't keep doing those, man. But yeah, I know people like I worked at FedEx, man. People would come out like and like I saw them in the parking lot sipping on them in between, like, and then they go back in and finish their shift. And then I'd see like Saturday mornings at the Friday night into Saturday. So like this night is Friday night for FedEx. Into Saturday morning, I remember seeing a guy like there's a guy I know, like he'd walk back to his apartment down the street, and he'd watch him just like pounding a Four Loko as he's walking down the street. And I'm like, what do you do? He's like, oh yeah, by the time I get home, I'm fucking shit-faced and pass out. I'm like, that's one way to do it, I guess. That's one way to do it. One way to do it. And Fair Frozen 55, good to see you, man. And then, watching the news, seeing those Blackhawks do CSAR over in Iran right now, trying to find the F-15 pilots. I got to get that Blackhawk finish, too. I got to get the Blackhawk finish. Like, I didn't realize, like, where it was sitting. It was under stuff. And I'm like, oh, yeah, we got to get to this. Now it's staring at me. So we're going to get back on the Blackhawk after the elephant's done. I will tell you that much. It says, Russell will only accept when he ends getting paid or a guarantee on a date with someone he's stalking. Yeah, and I know that. He'll never go away. He's like Rust. He'll never sleep. He'll never stop being a fucking creeper. So, never stop being a fucking creeper. He'll never stop scaring women and potentially abusing women. So, let's see here. Let me see. Did I miss something here? I'm trying to see. It's a never-ending drooling story. Oh, it 100% is. Useful Mistake says, well, he did pay the last sanction he was ordered to pay. After how many months? After how many months of motions to reconsider and bitching and screaming and crying about it? It took all kinds of threats, and he finally did it. But now we're going to be back to that again, and they're going to do the same. They're going to treat him like a little kid all over again. So, yeah, he'll pay the sanction probably by fucking Labor Day. If then. I don't think it'll be paid by Labor Day. You can that's my lock of the night. Russell will not pay that's sanctioned by Labor Day. I will be fucking shocked if he does. So, yep, the DAP is the direct action penetrators. I had my headphones on tonight because Sean was yelling so much that my husband in the other room kept answering, "What?" Well, I'm so sorry, Marlene. My bad. My apologies. David says Labor Day of 2027. No, Labor Day of 2026. David says the court won't even approve the amount by Labor Day. Yeah, I know. That's what I'm thinking. You like to think so. We should introduce Greer to Scarlett. Oh my God, that would be. You want to talk about fucking launching a torpedo at somebody? Fucking Scarlett. God, man, she is more destructive than. Man, she's more destructive than a fucking cluster bomb. Oh. How many people have fallen asleep to Sean's stream in the background wall? I bet a lot of people have. Given that's how boring it can be at times. So. Useful Mistake says, yeah, so give him another year and he'll pay up. So considering the other pending sanction, he might draw it up for 2 years. Hope the case doesn't last that long. Oh, God, I'll say it like this. I don't think we're going to... Matthew Harding could file a motion. He could be given the chance to file a motion for trial tomorrow. Let's say he was allowed to do that. We wouldn't be in trial this time next year. That's the fucked up thing. We wouldn't even be in trial this time next year, which is insane. But it is what it is, Chet. It is what it is. Scarlett's a J-Sal. Oh, God. I get that reference. Oh, no. And chat, no, the J-Sal is an actual thing. It is the joint standoff weapon. Hold on here. It's not just an 8th round thing. No, it's not that. It's a glide bomb. So if you guys are like, oh, the Russians did this, no, we've had these things for a while. It's a glide bomb. So it's a joint standoff weapon. That is out there, and everybody uses it. It's different than the JASM. It's different than the JASM or the JISM, which is what Aaron and Nick would use on each other, are the JISMs. The JISM bombs. And that's the AGM-158 JASM, which is a cruise missile. It's an ALCM, an air-launched cruise missile. So there you go. And yes, it's like an updated Tomahawk with a lot better capability. So yes, Nick and Aaron will shoot jisms at each other. And yes, Scarlett is a J-Sal, which is very, very appropriate. Very appropriate, Keopathic, that you are a cheeky, cheeky lad. The Ukrainians are winning when the Baldo cam comes out in 2 weeks. Well, that's true as well. I mean, I'll say this much. If the SBU, actually, if the GRU is out there, Budanov, if you're out there, homie, listen, I will fully support you. I will fully support Ukraine if you guys can run some sort of glowy op and get the body cam. Like, Slava Ukraini. I'll be fully on, salami ukulele if you guys do that. I promise. If not, I'll just hope the Russians glass Kiev in the meantime. So the choice is yours, sir. The choice is yours. Scarlet is a Sal, Ralph is a Boar. I know, but it's funny because the J-Sal is the actual name for the weapon. So, Shuggy said, I just joined watching on TV, and for some reason, Sean looks like he has something on his upper lip. I'm distracted by it. Oh, don't see anything. Don't tempt the fates. I sound like Trump. Based. I sound like Trump. And what with that, you know,
God bless you, Donald Trump. Keep the
Not on the
simplified
agenda.
fags out of our government.
I mean, God bless Donald Trump. Oh. Watch the body cam come out, Sean. Not supposedly I'll start supporting. Not officially I'll start supporting Ukraine. I'll fucking do it. I'll fucking do it. I'll do it. Legal Mindset. What's up, man? How you doing? Hope you're doing well. Hope you're doing well out there, man. So yeah, hope things are going well for you out there. You're gonna have to go to watch. Are you gonna be able to go to Johnny Somali's sentencing hearing? Because that's gonna be fun to watch him get hauled off. You almost need to like get photograph act like you or like Atoza. You guys need to like pay to get like a photographer in there. Just you guys could get a picture of him realizing he's going to prison. Like he's like, that would be the best. That would be the best. Yes. Yes. Legal Mindset. Oh yes, Legal Mindset selling the cabbage plushies. Yes, chat. He's selling the cabbage plushies. Legal says, interesting. I'm gonna be 50% on being able to go. Cool. But I'm definitely gonna have live reporting of it based. But yes, Ramsey Khalid Ismail. Yes, they're gonna be like Ramsey Khalid Ismail. Welcome to prison. In Korea. And he'll be like, oh, so that will be fun. Once again, good luck, Johnny Somali. Good luck. When does the Johnny Somali felting go down? I think it comes out later this month. I think. It's coming up. So yes, Anna Wall says, oh, I think she's talking about the plushies. Yes, they are adorable. Very much. The 15th of April. 2 weeks, chat. The meme is always evergreen. 2 weeks. 2 weeks. Objective Gestalt says wrong Asian stereotype. I'm a guy from Ohio. They all look the same. They all sound the same. Isn't that tax day? Yes. Beware the Ides of April, bish. Tax free. Joe Schmo, can't wait to get your cabbage. Oh, you did. You ordered one of the cabbage plushies. Nice. Katie says, I always thought Johnny Somali was Johnny Tsunami from the Disney Channel movie. I remember that shit from back in the day. Videos on those Korean prisons don't make it look awesome. Like, all prisons never look awesome. Like, maybe in Norway where you can, like, Anders Breivik gets a fucking PS5 and shit, which is kind of like, I get that if you do your part to help, save your country, based. But yes, the ones in, South Korea or Japan, you're forced to work and you better fucking learn language or they will beat you till you do. It's like going to the Foreign Legion. If you don't learn French, they will beat you into learning French. You will learn quickly. Korean prisons are very Spartan, and he won't want to go to the friendly foreign one. Yeah. I think I mentioned, you told me about it too, but Jeff did too, that it's full of foreign gangs. So like Russian mafia, Yakuza, all the organized crime that's not native to Korea goes there. So like, it's going to be rough. So Martha Stewart's prison didn't look too bad. Yeah, but club feds aren't bad. But those are hard to get into. You got to have some pull. Let's see here. Ag says he got another cabbage plushie emoji. Joe Schmo says, which gang would claim RKI? I don't know. Bald Eagle says, no, he's going to go to Korea prison because of the deep fake crimes. Well, he's really fucked then because it's like, he's going to find out about fucking racism when he's the only like non-Korean guy there. Oh, buddy, he'll have fun with that. So yeah, well, Johnny Somali will have fun. He will have fun. So guys, with that, we are all caught up. Andrew, you kind of joined right at the end here, but we covered what's going on. Ethan Klein and Denims. It looks like they're going to try to do summary judgment on one of the issues, one of the allegations of her copyright, not both of them. So we'll see how that goes. We covered the Stuttering John stuff, part 2. I don't think you're really caring about that at all. But then part 3, yeah, Russell Greer and the farms here. So I'll go. Also, I'm gonna have to message you. I need to know who did your plushies because I need to figure out to do some stuff because I was working with a company and I, somewhere in China, and they quit talking to me and they were like, goodbye. And I'm like, oh no, they probably got raided for stealing money. Or they're like, sorry, we're selling fentanyl now. We're making fentanyl, not plushies. So, oh, Johnny will go in as a criminal and come out as a fleshlight. Yes. Oh, they use U2s? Okay. Well, I don't know if they'll work with me. I've tried contacting them before. The Jumbo Shondal was awesome. Yeah, but it was a little awkward. We'll work on getting a better one here. Apton says, can you discuss bifurcated trials someday and why Lindsay Clancy would stipulate to killing your kids to get one? Yeah, I can talk about that, but I'm going to have to see what her case is about, Apton. If you could send me some stuff, I'll take a look at it. So, all right, guys, with that said, yeah, I've seen the Claymore plushie is not original. I've seen those have been like in the tactical world, there have been like tactical plushie Claymores for a while. So, there was even a Claymore with an Awoo face on it, or like the fucking Awoo kitten face I've seen that have been made before in limited runs. So that's not a new thing. Believe it or not, chat. You're not special. Oh. So, all right, chat. I got the next link set up for the next show. We're going to go over the model channel. We're making progress. We are making progress. I am learning this photo etch stuff. It's been pretty cool. We've gotten a lot out of it so far. And tonight we're going to get to the fenders of the elephant. And this is where we're going to start doing like battle damage. Like we're going to be tearing stuff. I'm going to punch holes in it. I'm going to try to start working on putting holes and damage to the armor that's on the tank. And I think it'll look pretty good. It'll look pretty cool here. The Chieftain had 2 plushies. Yeah, he's also got the emotional support missile. All that fun stuff. The Jimenez range report when? Probably end of April. I'll get that done. Have you seen the CCP anti-American propaganda? Well, I have. I've seen the one with the eagle and stuff like that. All it does is make America look cool. So, the Chinese are not very good at making us look like bad people. Like, as the meme goes, be the American the Chinese and Japanese think you are. Be the American the world thinks you are, because they think we're fearsome fucking people. They think we're based. So, have you congratulated April on her pregnancy? Is she pregnant? I mean, good for her. What about the Yemeni one for today? I don't know. Yes, there's a massive FBI data breach, and it's like, yeah, well, hey, there you go. Good job, FBI. While they were worried about American internal terrorism, they didn't get it done. So, fuck them. Years and years of going there. So, hold on here, Chet. I need to see. Is there any update to the weather out in my way? Oh, fuck. If you're in southern Ohio, guys, well, actually middle Ohio, like by Mansfield and Canton, fucking watch yourselves. You guys are going to get your shit rocked. Looks like Oklahoma City's getting fucking rocked right now. Sorry, I just turned on Ryan Hall for 1 second while I switch over the redirect. Yeah, too many resources were wasted on the Christian nationalists. You're like, why? Why did we do that? Apparently they thought it was necessary. You mean the former colonial New York territory, Ohio? Well, Actually, it was, well, Connecticut also had a claim to it too for a while. So, hold on, chat. I need to do this. All right, let's see here. There we go. Let's see. What did I miss? Anything here? Okay. All right, chat. So with that said, I will see you guys sometime. I don't know about tomorrow what we're gonna do, but you have a. Do I have a Kirsha plushie? No, I haven't bought anybody's plushies. I gotta go look at buying the. I think I might buy one of the cabbage ones though. Anyway, with that said, chat, we will do something tomorrow. I'm not sure what we're gonna do, when we're gonna do it. I gotta get some stuff done with 2.0, and then Sunday, guys, it's Easter. Let's celebrate him being risen. I don't intend to stream necessarily. So, with that said, chat, I will see you guys tomorrow. And remember, until next time, whose promo code is FENT for your gamer subs order? That'd be hilarious. Remember, until next time, chat, just because you did it does not mean you're guilty. Although Denims is probably going to be liable. Stuttering John's fucked. He's guilty of perjury. It's not going to happen, though. Russell Greer, well, he's guilty of being a tard. So, good night, chat. And you guys take care.
Weapons, blacksmithing, and models of planes, esoteric works, and even some trains. Much merriment had while drinking White Claws, tips on hunting, and even talking the law. Whatever you do, just don't talk to cops, even when they nab you on illegal stops. Just 'cause you did it doesn't mean you're guilty, but please talk to a local attorney. Was that
the Chinese people I was working with? I haven't heard from them. I'm trying to find a new group to work with on that, so we'll work on those. We're gonna try to get Clyde ones too, and like a plushie sandwich.
That guy Rick hated yelled at? Why, yes, it was. He even knows he's fat. For all this fun and more, there's one place
2.0 is kind of like very pirates, so we might have to just rattle. We'll be painting though with the rattle. Oh, you DM'd it? All right, hold on here. Sorry, Apex. I thought you meant you sent it here and I didn't see it. Oh, here we go. We're gonna... Hold on, chat. Let's hear this Durka Durka cartoon.
The commander of the mountain has arrived.
イエメン軍を支援し前線統一へのと試算した。この侵略が止まるまで。
Oh, this is so gay. Okay, well that's okay. Actually, that's kind of base attacking Israel.
イエメン、今はイランだ。全てを叩け。
This is pretty good. This is not anime psyop good though.
イスラエルは手だぬチェジョ。我々は重い代償を払わせる。
続報です。ホルム海峡の塞ぎにを正規レギキーが重化しています。とは経過量開始日。ソロビ薬はイカスのレウ入発に届かず、ガヤ核が非常事態を宣言。
トランプで異性のドモゼルのあなた氏しかいない。現 原野に隠れる不能性がある。これは誇張ではない。
イスラエルは以前して民間人を標的しています。ご覧のように私の背後でも。
Oh, I thought we were going to be bombing Yemen. Based. Based. Based.
今
Not
日は
based.
パレスチナ人の死刑を承認した。イスラエルの勝利だ。人の足を打った。欧州リーグだと多種類表だぞ。フランスは参加しない。
トランプはイラン抵抗もなく始めたということだ。A君の道理を終わらせる時が来た。
イギリスのようにジェットン領にが西かった国かへきつかるたるぜ。はいぞろ。ヤバいの生まれたからかもう確かつがたかったというに。
イスラエルはイランを潰したい。カタールもサウジもクウェートも。そして成功した。
We got Tucker Carlson.
ナムです。前回の対応に敵のダメです。ローハゲです。そして王はいない。マガは死んだ。トランプはイスラエルに忠誠を散った。
Israel will not take my soul.
次の大統領は親イスラエルではない。
Yeah, our next president will be pro-Israel. Like, we're going to be very hard-pressed to find a president who won't be pro-Israel. AIPAC whispers in every politician's ear. No matter who they are. No matter who they are. All right, chat, we're going to end right now, and we'll start the model stream. Also, thank you, Aphex. That was actually good.